All right, good afternoon, everyone. My name is Joe Calabrese. I'm a partner here at Bressler, Emery & Ross. And this morning, with my co-presenters, Ellen Slip, Sean Coughlin, Angela Turiano, and our first-year associate, Sanzita Talukdar, we are going to spend a little time talking to you about something we hope you haven't seen before, that is ethical issues in virtual mediation. I would imagine those of you in our space maybe are a little worn out with all the fun and super things you can talk about and having to do things by Zoom. But we felt it was probably worth having a conversation among all our colleagues that one thing that I don't think a lot of people, or we don't think a lot of people have thought about it is even though you're using this new technology, all the attorneys that do this type of practice or any type of practice are still bound by the rules of professional responsibility. And so we thought that might be a good way to spend an hour with you folks, trying to get you thinking about that a little bit in the most comprehensive way that we could come up with. We're going to do things a little bit differently than the average webinar. We're going to be working off of a hypothetical. My colleague Ellen Slip and I will be walking you through the hypothetical, and then my colleagues will walk through a series of questions and hopefully some answers and some insight into whether these questions about the hypothetical can be answered within the context of ethical obligations. We modeled our answers off of the New York ethical rules. We also included, however, for those of you outside of New York, the model rules. We're not going to post the rules during the course of the webinar because that gets really it's tough to do that in a PDF form. But as part of your packet that you got for signing up, all the sites will be available to you. So if you have any questions about that afterwards, we can certainly help you. Also, in terms of questions, we encourage you to ask questions. We encourage you to be as involved with the conversation as you can be, even though you're all muted. We're going to ask that you use the Q&A function as opposed to chat, because Q&A we can hold on to after the end of the webinar. If we don't get to your question, we can get back to you afterwards. If you're more comfortable with chat, certainly do that. That's fine with us too. We just lose the ability to hang on to it afterwards. We'll make every opportunity, obviously, to get to everyone's questions. Okay, so before we get into the meat of it, I do want to take a couple of seconds to introduce my co-panelists. We're going to go with age before beauty, so that's me. I've been with Bressler only for about a year and a half, spent a good chunk of my career at Morgan Stanley for about 15 years and came from public service, actually Citigroup first, then Morgan and the Brooklyn DA's office. The disclaimer is this: everyone that you see on the front of you all started in the same place. We're all ex-Brooklyn DA's. We've all been friends and colleagues going back at least 25 to 30 years, and surprisingly, we all still talk to each other. Sean and Angela are colleagues of mine here at Bressler. Sean, same career path as me, started in the Brooklyn DA's office, went to the General Counsel's office at Citigroup, and then Morgan Stanley, and has been a partner here at Bressler for the last 10 years. Angela Turiano, also one of our colleagues from Brooklyn, she worked at Merrill Lynch when she moved over to Wall Street from public service. Here at Bressler for the last, I think, 13 years, so she is the veteran among all of us here at the firm. And then finally, our good friend Ellen Slip, again, I think probably started before or just after Sean at the Brooklyn DA's office, moved over to Citigroup. And even though some of us moved over to Morgan Stanley in the merger, Ellen stayed with Citigroup, running their private bank litigation for quite a long time. And now she is a principal in her own mediation practice. So Ellen is a good friend of ours. We've actually started using her in the securities group for our mediations. She's got a really good grip on the issues and is known pretty well in our field, especially. And her mediations focus on either securities or employment disputes. If you need to reach out to Ellen, obviously her contact information is here, or you can reach out to any of us. But we ask you to consider working with her if you have an opportunity, because we think it's a good opportunity to work with somebody new in the field. All right, I think that covers everyone's bios. So I think what we should do is then move on to, oh, and I forgot to mention, I'm sorry, our first year associate, Sanzita Talukdar, is with us. She is a rising 2L at CUNY Law School, was a big help in putting this together. We completely appreciate everything she's done for us. We ask you to keep one thing in mind. Although all of us here, as I've just said to you, are part of the securities group here at Bressler, save Ellen, of course, we leverage input from all of our colleagues and some of the many other practice groups we have here in Bressler. So that includes our commercial litigation group, our employment group, professional liability group. So hopefully, although I expect most of you are from the securities world, even if you're not, this should be a good way for you to kind of take a look into this, because we were able to leverage some of the thoughts of our other colleagues too. We just couldn't put everybody in the same Zoom at the same time. All right, so I think now would be a good time to move into the hypothetical. Ellen and I are going to share the obligations of reading through it. We ask that you read through it with us. Obviously, it's in your materials, so if you have to refer back to it, that should be easier for you to do. So, beginning of the hypothetical, you have scheduled a virtual mediation over a business dispute between two parties, and your client, the company president, is deaf and uses American Sign Language, also known as ASL, to communicate. You generally communicate with the client via email, and for in-person meetings, the client's son, who is not a party to the action, has always helped out. He plans to translate all of the interactions with the mediator and the opening statements of you and your adversary. Elle?
You've used Zoom before, but you're not terribly adept at setting up waiting rooms and breakout rooms. You cross your fingers and hope for the best.
That's basically me. I wrote that for myself. During the mediation, the client and his son will be at their vacation home in the Virgin Islands, where their internet connection is spotty at best. As usual, the son has agreed to interpret for your client. You both agree that using the Zoom chat feature in private mode is how you'll communicate in real time during the mediation. The client consents to using the chat feature, but prefers conversational-like communication to express his thoughts and ideas, and prefers that his son translates for him, especially when it comes to making and accepting offers. Not surprisingly, while you and the client are meeting virtually with the mediator, the client's signal fails, as it has happened to all of us, and he and his son drop out. For the sake of time, you move ahead, speaking to the mediator without the client present, agreeing just to fill him in later.
So during the course of the mediation, again, this is something that's happened to some of us, thankfully not me yet, you mistakenly send sensitive information in the public chat session to your client, but the client does not notice that the information was sent to the other side. Seizing on the information, your adversary makes an insultingly low offer. So you can tell everybody that we've packed this hypothetical up to the brim with all kinds of issues that hopefully won't present themselves, but it is a perfect hypothetical for the discussion points and the questions that we have plucked out of this hypothetical for our conversation. So Angela, we're going to start with you. And this was a question that I grappled with doing a PLI last September. And at the time, it was new to me that, that this is actually something that you need to educate yourselves about. So Angela, are we ethically obligated as attorneys to know how to work Zoom?
Thanks, Ellen. So yeah, so when I first heard this question, intuitively, you think to yourself, really, I have an ethical obligation to know how to use Zoom? Doesn't seem like that's something that we as lawyers need to be, it doesn't seem like we need to be technologically sufficient. However, as it turns out, crossing your fingers and hoping for the best is not sufficient in this particular area. And for that, we go to Rule 1.1 of the Rules of Professional Conduct in New York, which basically is the duty to competently represent your client. So within that competent representation, the rule, that's the substance of the rule. If you go into the comment of the rule, it specifically states that one of the responsibilities of a lawyer is to keep abreast of the benefits and risks associated with technology the lawyer uses to provide services to clients or to store and transmit confidential information. So embedded in the comments of the rule is in fact an obligation to basically be competent technology. And it goes on to say, not only to provide services, but in fact to transmit confidential information. And we're going to talk about that aspect of the hypothetical, as you might imagine, a little later on in the presentation. But you know, it is interesting because when I first heard the question, I said, well, why do I have to know? Because like FINRA or AAA will administer the arbitration, but that's not always the case. Sometimes you don't have an ADR provider doing it for you. So you need to be able to understand the technology for yourself, and you need to make sure that your client understands the technology. Something else I'll point out real quick is that as it turns out, the ABA also issued guidance with regard to the virtual practice of law just this year in response to the obvious uptick in virtual law practice as a result of the pandemic. And the ABA guidance, it's a cautionary ethics guidance on virtual law practice. And they comment both generally and specifically with regard to being proficient in technology. And the language actually specifically states that the ABA model rules of professional conduct permit lawyers to conduct practice virtually, but those doing so must fully consider and comply with their applicable ethical responsibilities, including technological competence. So it is pretty clear that we need to know what we're doing, and we can't just cross our fingers. So I'm sorry, Sean, did you want to add something?
Right. I really think this scenario assumes that the practitioner is putting together the Zoom platform for the mediation parties. And oftentimes, as you mentioned, Angela, if you're doing the mediation with someone like Ellen Slip, or through her services, or through FINRA, or through the court, they may well have a platform there. And then I think your obligation is to understand how that platform works. Most of them are the same, but there are little differences. Oftentimes, if you use FINRA, you will be put in the rooms by them. And so some of the scenarios that can happen that we've laid out here, it's harder for those things to happen. But if you take on, if you agree with the other side to host the mediation, I think you've got the same duties that you would if you were in a physical space. You got to make sure the other side has their own room, that they have privacy, that you have privacy, that there's no means for you to quote unquote overhear what's going on. And so in one way to do it is just go back and think about what your obligations are under a brick and mortar world and just apply them here.
And just to add to that, Sean, I think that even in a physical brick and mortar conference room mediation, obviously preparation is key. I think the technological overlay here makes that preparation even more important. I've done mediations with elderly claimants, people not as tech savvy as some of the people attending this conference, but it's doing a dry run and making sure those glitches are preventable and addressed in advance is 99% your road to success. So I think preparation is very important, particularly with the technological aspect of doing a Zoom mediation.
And Ellen, I'm glad you brought up the word preparation, because actually Rule 1.1 also in the comments section talks about thoroughness and preparation, and it requires lawyers to adequately prepare for the trial, the hearing, whatever it is. And certainly adequate preparation involves your understanding as well as the client's understanding of how to use the platform. And overall, it'll just make the day run smoother. Just like if you're in person, if you don't have things set up in advance and you're running around trying to find the room to go into, or whatever it is, it's just going to take away from the substantive purposes of you being there, of you trying to settle the case. So yes, you're correct. Preparation is key. And that is also a part of Rule 1.1 and your ethical obligation to your client. So with that, we are going to move on to the next question, which is, should the sun translate? And I don't know, Sean, should the sun translate?
In an ideal world, I don't think the sun should translate, but you've got interesting facts here. This particular client has turned around and told you he wants to use his son to translate. So I think the very first thing you got to do is be mindful of those risks and share those risks with your client. And in this case, I think you need to share them in writing with the client without the son's involvement at all. So you've got to point out the fact that there are some scenarios where because the son is involved there, you are essentially breaching that attorney-client communications, right? You've got a non-party involved here. And so that opens up the door in some scenarios, potentially. Let's say this mediation goes bad and information is exchanged there, that you could see the other side saying, I want to depose the son, and start asking questions about what he was told about the case. All right, so you've got that scenario. So what's the best practice? The best practice is to outline what the risks are of having the son translate. One of those risks, of course, is what is the son's ability to translate? So you got to outline that, and then you've got to make sure, and I think this is really crucial, you've got to make sure that when the son is translating to you, remember our fact scenario says he wants the son to translate about the settlement discussions, the authors, the demands, the back and forth. You know, are you getting the real information from your client? Or is the son stepping in and really opining on what he believes should be going on? And how do you know who is really delivering that information to you? I almost think that what you need to do is go back and in a separate email directly or text directly with your client, confirm your understanding of what the son translated to you. Okay, that's going to be your best practice. So you need to turn around, you need to get a written disclosure or, you know, from the client. I'm sorry, you need to provide a written disclosure and have it signed by the client about the risks of having the son translate. All right. You need to inform the client that there is a potential of breaching the attorney-client privilege because they're using the son to translate. Now, one way out of this is not having the son translate, but, you know, hiring a professional translator. Okay, that solves that problem. But for whatever reason in our scenario here, this guy who has a house in the Virgin Islands is a little too cheap to use a professional translator. And you can find comments on this under New York Rules of Professional Conduct, Rule 1.14, Comment 3. And it was really just published this past year in 2020. And there was also under the New York Rules of Professional Conduct, Rule 1.0J. Outlines the fact that you really need to make sure you have an informed consent signed off by your client. And I think you need to do that without the son translating it for you. You need to do it the same way you've been communicating up to this time. And this is something that needs to be taken care of before the mediation.
Now, Sean, here, correct me if I'm wrong, but aren't mediations by their nature confidential? You go to a mediation, the mediator starts off, speaks to both parties and says, just so everyone knows, this is confidential. What we say here is just meant for here. You know, what happens in mediation stays in mediation. So what's the concern then for the exposure of like the non-party witness?
Right, you're right. Normally it's confidential. It's confidential in that if I make an offer of $200,000 and the other side says no, right? They can't turn around later and say, we offered $200,000 at mediation. They can't turn around and say information that was provided to them, you know, during the course of mediation and rely upon it. But in this scenario, what could happen, right? Mediation fails and the other side, for whatever reason, knows that the son has been translating here these communications with the attorney. They can turn around and subpoena him to depose him, okay? And I mean, we're not talking about communications that were made with the mediator necessarily, right? We're not, and if you think about it, you can depose him for any and all communications done outside of the mediation, because that's how they want to, you know, communicate. So from the beginning of this case, when you get involved in this case, if you're told that there's going to be this family member who's going to be translating, your antenna needs to go up and you need to think hard about some of the issues that are going to come up there, whether they're competent translator, and make sure your client understands that this is really breaching your relationship, the attorney-client relationship with him or her. And then lastly, you need to make sure that you're comfortable that through the course of the translation, you're getting your client's wishes and not the child's wishes. And that doesn't matter whether it's a translate from, you know, the Spanish to English or from American Sign Language to English. Those issues exist where a family member gets involved with translation like that.
John, we have
three more, but, oh, I'm sorry.
And maybe Ellen, you can help us out with this too. We have a question in the Q&A.
Mhm.
Is there a material difference, or what happens? And Sean, I think you touched on this a little bit. If the son is a professional translator, we'll move the family dynamic out of it. But if you hire someone as a professional, do you still have issues with breach of attorney-client privilege, breach of confidentiality? If you do go and spend the money, does it really change some of these issues?
I don't think it changes the ethical issues that have been presented in the loaded up hypothetical here, whether you're paying for the translation services or if it's gratis because it's a family member. I do think that there are some protective measures that can be taken in advance of the mediation. Number one, you should try the best you can to understand who is going to be present. I had a mediation where, unbeknownst to even the claimant's attorney, the recently widowed Moskowitz, to quote my friend Harry Walters, invited her three adult children to attend the mediation, all of whom happened to be lawyers. So me as the mediator, that was quite problematic because even though they weren't translating sign language or Spanish, they were putting their own sort of wrapper around mom's case. And to Sean's point, you absolutely need to be sure, you as lawyers representing a claimant or a respondent even, that you are speaking directly to the actual client, not some of these other folks who might be at the mediation. Real quick, before we move on to the next question, I always try to get all present parties to sign the mediation submission, for all the parties' protection, in addition to the mediators. And also in advance of the mediation, when people pop up on the screen, please make sure that they are not recording the proceeding, and make sure that you ask them if there's anybody else in the room. And that will go a long way to, the dire circumstance after the fact, if it doesn't settle with, the possibility of, having people breach confidentiality and introduce documents and theories of the case into an arbitration later.
I also just add to that, it's my understanding that the attorney-client privilege would not be waived in the presence of a professional consultant translator. I think that's the case because it's a hybrid person, it's an extension of your client.
Excellent. Okay, I'm just watching the time, so if we can move on to Ellen, question 3, that would be great.
Okay, so the question is, if there's, you're not in the Virgin Islands, you're in Puerto Rico, or you're in Lake Placid, wherever you are, and the signal drops. Can you, as an attorney, move ahead with the mediator if you've lost the connection? So basically, again, the rules of professional conduct speak directly to this. And it specifically indicates that, yes, the lawyer can move ahead. Your obligation is to inform your client of quote unquote material developments in the matter. So say the signal drops and lawyer to mediator are just talking and teeth gnashing and saying how much the other side is unrealistic about their version of the case. Are those material developments or not? Well, if you're learning something new, then you as the lawyer should parrot those developments back after you get signal, or even if you're just going to pick up the phone and forget the Zoom altogether and go, ear to ear on a cell phone. To this point, there are guidelines for mediators published by the various ADR outfits. FINRA does not have ethical guidelines. What they do is mirror the ABA guidelines. So if anyone has a question about the FINRA ethical obligations in mediation, they just cite back to the ABA, and that can be found at americanbar.org. So Angela, I think you're going to pick up the next question.
We got the floor faster than I thought. I had muted myself. Sorry, I would have moved you on.
I was just sorry about that. Yes, this is my question. So what should you do when you realize you sent the private information publicly? What should you do? We'll get to what you should do in just one second. Let's first talk about how you should have prevented it from happening in the first place. And, you go to the model rules and it says a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of confidential information. So the question here is, all right, what is a reasonable effort? And actually the rule itself actually does define confidential information. It defines it as attorney-client privileged information, information likely to embarrass or be to the detriment of the client, or information that the client has requested be kept confidential. Here in our hypo, we just have that it's sensitive information. So again, the key word is reasonable efforts. What is reasonable? You have to dig into the comment section of this rule to find out what is reasonable, because it does not constitute a violation of rule 1.6 of making reasonable efforts if you took reasonable efforts. So if in our scenario, if the lawyer here made an effort and was reasonable and this got disclosed because it was some fluke on Zoom or something like that, that wasn't his fault because he didn't know the technology, then he wouldn't have been in violation of this rule. So what do the comments say about what's reasonable? Well, they give you like a list of what you should look at to determine reasonableness. And the list includes the sensitivity of the information. Well, here we just know it was sensitive, but it was certainly sensitive enough to cause a lowball offer. So I think we've met that criteria, that it was sensitive enough, that it was not good, that it was disclosed. There's also the likelihood of disclosure if additional safeguards were not employed, and the cost of employing additional safeguards. Here, what would have been the best practice would been to just get themselves up and learn about the technology of Zoom, and maybe not even to use the public chat feature at all. Perhaps there would have been a better way to communicate than, which it probably would have been, so you avoid this altogether. There's also the difficulty of implementing safeguards. Again, none of this would have been difficult to do. So it seems in this scenario that, in fact, the lawyer did violate his ethical obligation under Rule 1.6 for reasonable efforts to prevent the inadvertent disclosure of confidential information. So which leads to the next question: what should the lawyer do in this situation? Well,
Angela, can we back up just a second, because we did
Sure.
get a question in the chat that I want to talk about a little bit. Is, really simple elemental question, right? Isn't the most prudent and responsible course not to use that function, right, during the mediation or any other meeting for that matter, when you've got an adversary on the side? Like, why take the risk of doing something like that when even if you make your best efforts, even if you're doing everything you think you're supposed to be doing, you can expose things to the other side. And I'm interested in everybody's thoughts on that. I can tell you from experience that keeping the client looped in the way they want to be looped in is important. I think you all know this. Anybody who's involved in litigation should really consider that in order to get their client involved in the process and feel like they've been part of what's gone on and haven't been told what to do by you. You have to communicate on their level. We built the hypothetical intentionally to bring this in a little bit. We also talked about the fact that it goes back to the translator issue, that the client likes in-person conversations. So I think it's a really good question, but why don't you just not do it and avoid it altogether? The problem is, A, you may not have a choice depending on the physical setup that you have. And B, you may have a client who wants to communicate that way. And sometimes you have to do things like that to keep them happy, to keep them engaged. I think a lot of us have found ourselves in a position where, I'll give you a perfect example. I have certain clients who only want to talk to me on the phone. We'll talk about it on the phone. I don't want you to put it in writing. And that's fine, right? Because the phone, I think we could all agree, is the safest way to guard against attorney-client communication breaches. It's also hard, however, without sending a confirmatory email, to remember what you told them and have them remember what you told them. I also have other clients who say, I don't have time to talk to you, put it in an email. Okay. And you presume that you're going to put privilege on the top of that email. You presume that your system is solid. You presume that their system is solid. But everyone knows the minute you put something into writing, you might have an issue of a breach. We all know, though, that reducing things to writing sometimes is necessary to make sure that we're precise about what the advice we're giving our client. So I think it's a really good question. I think what it comes down to is what your client's comfortable with and how willing are you to kind of interfere with that comfort level to prevent something you should be on top of. Two things I want to do. I want to give the code first. I'm getting questions, did I miss the code? If you were listening, you didn't miss the code. So the first code is, we're doing 2-word codes today because, I don't know, I got to choose. And the first one is, and it's going to shock you, on mute. 2 words, on mute.
So Joe, going back to this question that we're grappling with, I think, again, to be like the practical tips here, I think there are ways that we can avoid disclosing information that's not meant to be disclosed. And I'm going to take it back to the pre-mediation, showtime stage, where I think, again, preparation is key. And in the mediations that I've done, I have asked people to trust that I will keep documents confidential. And I ask them to send me not just the 2 or 3 pager on mediation statement, but also any documents that otherwise would have been slid over the conference room table at a physical mediation, to let me see those in advance. Because that, number one, is going to eliminate the possibility of an oops moment where things are shared publicly. It also practically makes the actual in-person Zoom mediation much more efficient, because I, as the mediator, have had a chance to digest the information, call the parties, ask any questions, kick the tires a little bit, in advance. So I think that's a very practical tip. Of course, it involves trusting your mediator and trusting that he or she will not disclose things to the other side without express permission by the party. Another thing that I've seen happen is, you have the mediation, you have all the parties' cell phones and email addresses, of course, because you're setting this up. And what I found to be very useful is to have two screens up. First of all, you're going to have your camera screen, and then you can have another monitor if you're lucky enough to have a second monitor, or you have your iPad or your phone. And so if there's a document that comes up during the course of the day in the mediation, you can just ask the lawyer for the particular party to send it offline, not on the Zoom function, not on the function. Just send it as they would normally any other document. And that, there's obviously downtime when the mediator is discussing issues with the other side. So there's plenty of time to do that. And as we all know, issues that you really didn't think were going to be important issues during the course of a mediation sometimes get to be, the biggest impediment to progress. Things that you thought would be sort of, de rigueur and, plain vanilla type document. All of a sudden, the litigant has a new theory about that particular document, and you're going to want to put that in front of the mediator so he or she can give it the truth test and digest that information, him or herself. So I think not that we shouldn't have trust in Zoom, but twofold with preparation in advance and with using other avenues of communication. I think the inadvertent disclosure of documents not meant to be shared with the other side can be avoided.
Yeah, and just to add to that, the issue with the communication, I know Joe mentioned that in this, maybe the client wants to be communicated with in that manner, but certainly you can communicate just like Ellen mentioned, like offline, just like you can send a document offline. Like instead of using the private chat function, why not just, you're in the middle of the mediation, why not just put yourself on mute and go to the phone and send them an email or communicate them offline? And that seemed to be would be the safer, more reasonable, going back to the rule, more reasonable thing to do here. The other thing is, if you think that there is going to be any sort of type of document sharing in a virtual mediation for whatever reason, then why not include it? There usually is a mediation agreement signed in beforehand. Why not include some kind of stipulation between the parties that if there is some kind of mishap with document exchanges or whatever it is, that the parties agree to return it and don't read it. And that kind of like we have in our confidentiality agreements in discovery in our arbitrations or litigation. A clawback provision, so that if for some reason, reasonable or unreasonable, a document is inadvertently disclosed, the other side will agree to return that document or whatever, however you want to put it in writing. So there's definitely reasonable steps you can take to avoid this kind of disclosure. And it's something, again, that people need to think about. Like we said at the beginning, that these are things that you don't necessarily think about beforehand if you haven't done a number of these virtual mediations.
We have a couple of questions that came back to question number 3. And I'm curious, Sean and Angela, or even Ellen, obviously, what you think about this. And that question was, should you move ahead with the mediator when the signal drops? When we were all traveling to do this, everybody looked at their watch at 3 o'clock and said, I've got a 4:30 flight. This needs to end now or it's not going to end. We don't have that problem generally today when we're sitting on Zoom. But I think we've all been in the situation where time becomes, time management becomes an issue. Time management with the lawyers, time management with the parties. The signal drops, you can't get this guy, he's not answering his phone, and you want to move this thing ahead, and you know what the client wants you to do. It's not as if you're going to work outside your authority. What do you think about just moving ahead without this guy and then deciding later on to fill him in? I'm curious about your thoughts on that because a few folks have asked.
I think oftentimes it's one of those things you almost need to talk to your client beforehand about the possibility of that happening, so that you've foreseen that. And so you explicitly get permission to move ahead. You find out from your client, what their bottom line is or where they're willing to go to. But you still have an obligation afterwards at some point in time to catch them up and let them know, what the points were made, what the offers were, to what extent you put a counter offer on the table. You can do that. I think things change, however, if issues come up that you did not foresee, if a new theory of the case comes up. And I think then, if you've not covered it with your client beforehand, you're moving outside your scope of your authority. Angela, what do you
From the-
think?
Even if you, so you're saying even if you're doing it and then you advise them of it after the fact, you think it's still,
You know, if I think if you covered things beforehand and you say, you know, there's a possibility because you're in the Virgin Islands and we're here that the signal may drop. All right. What authorization do I have to continue with this mediation? I mean, moving ahead and getting information and speaking with the mediator is one thing. Once you do that, you have an obligation to turn around and communicate all of that to your clients. But I think we're talking here is a continuation of this mediation where you're not including your client.
Well, what about the situation we all have found ourselves in person, where the mediator, you're sitting in the conference room with the client, the mediator opens the door. For those of you who know Howard Island, you do this all the time. You go, come here. And then you wind up standing by the copier where he keeps all the cookies and have a complete conversation about what should be going on in this case, outside of the presence of your client, because he thinks that you need to approach this differently. Is that any different than going ahead because the signal dropped?
yeah, I was Joe. I was going to bring up a similar scenario, although I wasn't going to use the Howard Island and the cookies, which was very good. But I agree with that. Is it different? Like, doesn't that happen in in-person mediations where, you know, you're away from your client and the mediator comes over to you and says, or maybe we need to have a conference between the two lawyers, and then things just roll and you don't go back necessarily and say, oh, I'm just going to be speaking to the mediator for 5 minutes with the other lawyer. Sometimes things just roll along and you just want to keep things moving. So is that different than the signal dropping?
Some of that stuff, you should be covering that when you talk about the mediation to begin with, right? You should make sure your client understands what's going to be going on during the course of the day, so that you know they're really not surprised. Oh, I see that Sean is going to go talk to the mediator now. Shouldn't be a sudden causing your client to fret. It's something that, you know, we've all done a lot of mediation, so we, you know, when we discuss going to mediation, we should be discussing what happens at a mediation, and that's one of the things that may come up.
I think that's right. I think you just have to make your client aware that this is what might happen and this is what you're going to be doing, and then always, of course, inform them at the end of your conversation of what went on, so they're fully apprised.
Right.
But I think that's correct.
Ellen, what's your
the
practice
concept-
in moving people in and out?
Forgive me, Joe. I was
Yeah, Ellen, what's your practice in separating parties from their lawyers in order to get them to where you want them to be? Do you think there's an
Well, you know, I find that it's just like the scenario that that you talked about with the cookies, right? And by the way, it's hard to send virtual cookies, so forgive me if I'm not sugaring people up during the course of my mediations via Zoom. But you know, on the informed consent issue that Sean raised, it's actually defined in the New York Rules of Professional Conduct, Rule 1.0J, which again were just revised in 2020. So informed consent, and it goes to Sean's point about, you know, managing your client's expectations and getting them to understand that if they speak privately with the mediator, it's not, you know, talking quote unquote behind their back.
Right.
So I encourage all the attendees to read that. And I also have embedded in my mediation agreement something that was much more obvious in in-person mediations. And that is the fact that the person with actual settlement authority needs to be present. And being present in a virtual mediation is different than being, you know, in the conference room eating cookies. The person with the actual settlement authority must be present. And whether that means a phone call away, a cell phone call away, whatever it may be, that can be an impediment of progress. And I make sure that that is disclosed to the attorneys in advance. So, you know, if there's, you know, an expert witness who's inserting themselves, or if there's a trust and estates lawyer who's inserting themselves, the mediator has to fully understand that those people are not the decision makers, and the attorneys in the room have an obligation to listen to only their client. And to your question, Joe, what I find is that during the course of the day, you know, you start with a group session. People, I don't encourage opening statements. I don't think most mediators do. And then over the course of the caucuses, you know, the Zoom thing kind of gets winnowed down. And then there may be more conversations when you're being at the end of the day trading numbers, usually around, like you said, Joe, 3, 4 o'clock in the afternoon. It becomes a telephone call between the attorney and the mediator. And, you know, trusting that most people I'm going to believe that all people are ethical. They're going to be communicating everything with their clients as they're obligated to do.
Excellent. Thank you, Al. Sean, I think we should push on to going back to where we left off about communications.
So wait, so I just want to finish off what I was going to say. I never answered the question. What should you do if you
Yeah,
send?
sure, go ahead.
Okay, so I just went over. So what you should do is immediately ask for it back, or ask if they stop. Once you realize it, immediately ask for it back. Ask them to stop reading it. Ask them, and that's going to segue right into our next conversation with Sean. But I will point out here is a difficult situation because we're not talking about a document. We're talking about some information that went into the public chat that obviously was some I guess weakness in our case that made the other side give us a lowball offer. So it's a little bit different. It's like the toothpaste is already out of the tube, but that still leads us to our next section, which is what is the obligation as the attorney receiving the inadvertent disclosure or document? What are the obligations of that attorney, which is actually can vary by jurisdiction. But I'll turn it over to Sean to discuss that. Before I do that, though, I just want to mention that, Alan, the virtual cookie thing might be a good idea because that's maybe a good way to drum up business. Even better, maybe you can consider like virtual cocktails. Then you'll get a whole bunch of new business, right? Anyway, I'm sorry. Go ahead, Sean.
Noted.
Virtual cocktails. I have to follow that. Great. I kind of always, when you think about this, and it happens, right? You're going through a production of documents and all of a sudden you look at something and you realize, I'm not supposed to be reading this, okay? And there, as an ethical attorney, you've got to do the right thing and pick up the phone and call up your adversary and say, hey, you produced this to me, I'm returning it to you. And you're supposed to not rely upon that. The rule is Rule 4.4b under the New York Rule of Professional Conduct. A lawyer who receives a document relating to the representation of a lawyer's client and knows or reasonably knows that it was inadvertently sent to them shall promptly notify the sender. So I really here, I think, you're sitting, you're reading the chat. I think you need to turn around and say, hey, Mr. Smith, you just sent that out to everybody. All right. That's what you should be doing. Just like if you wind up getting a bunch of pages in discovery that are notes between your adversary and their client. Okay. You would hope that they would have the same professional courtesy and ethical obligations to you and return that stuff to you as well. And then, the second part of Rule 4.4, Comment 3 is an attorney must refrain from reading or continuing to read the document. So here it gets interesting. How much was really put out in the public chat? If it was a one-sentence thing that you're just reading the public chat, well, you've inadvertently read it. I think there your obligation is to tell the other side what they put in the public chat. All right. If it's 7 paragraphs, right there, you have to tell the other side you put this in the public chat, and you also have to stop reading it and ask actually that it be taken down from the public chat. And that's your best practice here. Of course, depending on who and what your client is, they of course want to have the secret sauce, right? Isn't that what it's all about? So it's something that you need to deal with there.
So I just want what I mentioned before, it differs in jurisdictions. So it's very interesting. So if you look at the New York rule here, 4.4, the actual verbiage of the rule just says that if a lawyer who receives a document that was inadvertently sent shall promptly notify the sender, and that's it. Yeah. And then the comments sort of extrapolate, and the comments are actually a little bit confusing, which if I have time, I'll get to in a minute. As opposed to New Jersey, the actual verbiage of the rule says, shall promptly notify the sender and shall return the document, or if electronic, shall delete it. So it's pretty clear in New Jersey that your obligation as a lawyer, once you know and once you've been notified, that you need to return the document. Whereas New York, while the comments do say, they do mention that you need to stop reading it, the comments are actually very confusing. It actually, in comment 2, it actually says the rule does not require the lawyer to stop reading the document, but if you read or continue to read a document that contains a privileged or confidential information, you may be subject to court-imposed sanctions.
That's just it, yeah.
Which is just crazy. And then even in comment 3, it goes on to kind of give the lawyer some discretion. It says, because there are circumstances where a lawyer's ethical obligation should not bar the use of the information obtained from an inadvertently sent document or other writing, this rule does not subject a lawyer to professional discipline for reading and using that information. And then it kind of ends the comments by saying that basically the decision are matters of professional judgment reserved to the lawyer. So if you go, and I encourage you to, if you're interested, to read the comments, because they really are very confusing. And I imagine it must lead to a lot of litigation in New York courts when these things come up about whether or not the attorney is in the circumstances presented ethically obligated to return or delete the document. Whereas New Jersey, it's like, you got to return it. So it's just interesting, and it's something that people should know in varying jurisdictions, what their specific state rules require when there is an inadvertent disclosure. So.
That's a really good point. It comes back to, I didn't know that was the rule. Well, right. You don't want to, that's not going to be your answer in front of the disciplinary committee, right? I didn't know it.
Go ahead, sorry.
No, it's a nuance, right? Some state makes you do this, some state makes you do that. And I think most people, after they finished in law school, what's called pro row, and you took the ethics exam before the bar exam, that's as far as people went, because the thought always is your gut tells you with what's ethical and what's not. I mean, it should. You'd be surprised, right? But in different jurisdictions, just like you point out, that might not be the case. So depending on where you are and where you practice, you got to be up on this stuff, because I think even in the last 5 years, and I don't practice in front of the disciplinary committee, but the sense of humor about a lot of this stuff has disappeared. And the length that the disciplinary committees in either states, I'm registered in New York and New Jersey, and I read these decisions about people who get suspended, or if it's really terrible, disbarred. There's not, other than cooperating with them after you get caught, there's not a lot of room. So I think it's a good point to know it today. You have to explain to somebody that you really didn't mean it tomorrow. I'm good to move on to question 6, unless everybody needs to stick on this or has any questions about it.
Well, I was going to just add for this particular scenario. So what do we do here? Because it's a situation where you can't really return it. So you're the lawyer on the other side to get this information. The person says to you, our lawyer says to the other side, oh, don't use that information. So normally I would say best practice is like, you get a document that's inadvertent. Most lawyers, and there's a couple of scumbags out there that won't, but most lawyers out there are going to return it and say, listen, I didn't mean to. But in this situation, how do you do? Would you use it? You're not going to use it. What are you going to do? I think, how do you not use it?
In public, like.
I mean, how do you not use the information to get a better settlement? You already read it, right? So.
Horse out of the barn, right? That's what they say.
And that feeds right into question 6.
It does. So, and even with juries,
like
right?
That.
With juries, they say the bell's been rung. You ask that question, you shouldn't ask, and then the judge yells at you, and you apologize, but you got the thought in somebody's head. It is not easy. So, right, thank you, Al. That gets question 6, and question 6 is, knowing the offer is artificially low because of the inadvertent disclosure, do you take the offer back to your client, thereby possibly exposing yourself, or just deny it out of hand? So I think this is a tough spot that a lot of people have been in the past. We're all human beings. We all make mistakes. It's easy to say that a colleague lost track of discovery. They shouldn't have. They said something. It wasn't an inadvertent email. It wasn't on a recorded presentation. There's no one in this field that's immune to that whatsoever. But you're now stuck with the fact that if you go back to the client, he's going to know that you did this. Well, the reality is you should have told the client in the first place, right? It's easy to sit there and say, what do they say, that courage is what you look like in the light, not what you look like in the dark by yourself. The rules cover these, and the rules say are very simple, right? So a lawyer has to promptly inform a client of any material development in the matter, including settlement and in the criminal context, plea offers. But more importantly, a lawyer has to explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the presentations. Both of these come out of 1.4 in the New York rules and the 1.4 again in the model rules. Look, the bottom line is you're the only one. You and my dogs are the only one. It's just an imperfect world. They'll be speaking momentarily. You're the only one who knows that you made the mistake. And I think a lot of lawyers wind up in the same situation. They're the only ones who know they made the mistake. Who do they have to tell? Listen, you have to do unpleasant things every once in a while. And the rules are very clear. You got to let your client know what's going on, right? You have to let them know what's going on. You have to let them know what you did. You have to let them know what you did to remediate some of those issues. And then you have to tell them, look, by the way, this hurt us. You can find a pleasant way to say it. You can find a less direct way to say it, perhaps. But I have found in my practice that giving bad news is like pulling off a Band-Aid. Get to the point and get it over with. Because you never want to be accused ever of misleading your clients. You know, after that settlement document is signed, people always have buyer's remorse. I think Ellen will tell you this, or anybody who's done a mediation, right? The best mediation is when everybody walks out of the room a little ticked off. Nobody got exactly what they wanted. But I have had situations where adversaries have called back, and I know it's a waste of phone call because I'm not going to do anything. And there was some buyer's remorse there. And if people really do get that buyer's remorse, the first thing they do is bring up something they said they didn't know about. I didn't hear that from my lawyer. This is much more, I think, in the context of criminal, which is not what we're talking about today. But every once in a while, that's going to happen. So how do you avoid that? Well, the way that you avoid that is being as upfront with your client as you possibly can. I don't know. Does it rise to the level of memorializing it? I don't know. What do you guys think about that? Is that worth putting in a letter to the client or something so that you know that there's a clear record that you disclosed what the error was? Or is that going too far?
I think that you want, if you want to be in a situation, you never want the punishment, what's the phrase I'm looking for? To be worse than the crime, the cover up to be worse than the crime, right? So you need to disclose 100% what happened. I don't know that you need to memorialize it as long as, I don't know that you need to memorialize what happened as long as your client is aware of the mistake. Then I think it's fine. I think there's probably ways you can like soften the news, but you definitely need to disclose it.
Gotta disclose it though. You
gotta disclose it. And as much as you don't want to, as much as you want to say, oh, what can I do so they don't realize this happened? It's definitely your obligation to disclose that something happened. And hopefully you can, through your brilliant lawyering, you can figure out a way to salvage a decent settlement out of the situation. But I think it's a no-brainer.
We have a good question in the QA. Isn't it true that in many jurisdictions, the attorney that received the information, so that's not you, it's the other person, would be disqualified from representation because he or she had used confidential information belonging to someone else? I guess my question is, how do you prove that? That's number one. What do you think about that? If you let something go, does it automatically disqualify the other side? I'll give it to anybody. Ellen, I'll give it to you. What do you think? Does that disqualify the other guy?
I think that's probably, as the anonymous attendee said, that it's a jurisdiction by jurisdiction question. And not that I'm offering to my friends at Bresler to do a 50-state survey on that. I personally don't feel comfortable, answering that question shooting from the hip, but I think it's a great question. And if Anonymous wants to tell us what jurisdiction he or she practices in, we could probably get an answer back to that person. But Sean, Angela, I don't know if you guys have any experience with that.
Real quick, one of our other participants gave us a little bit of flavor from Texas. So per the Texas Center for Legal Ethics, opinion 664. So maybe we should ask you to help us with our next one because you're researching while you're listening to this. The Texas Disciplinary Rules of Professional Conduct do not prescribe a specific course of conduct a lawyer must follow upon the unauthorized or inadvertent receipt of another party's confidential information outside the normal course of discovery. Although the Texas Supreme Court has stated that upon the unauthorized receipt of such information, a lawyer should aspire, I guess that's the right word, we all kind of said that, to the standard of conduct prescribed by non-withdrawn ABA opinion 94-382. A Texas lawyer does not violate the Texas Disciplinary Rules of Professional Conduct by failing to follow the standard, including the requirement that gives notice of the receipt of such information to the opposing party. I would venture to guess that is a much different standard than those of us here in New York. But it is a different way of looking at it. Yeah.
But then you also have, you see, like the New Jersey rule specifically states what the lawyer must do. And then I think, and again, as I pointed out, the New York rule is very, very confusing as to like what you're supposed to do. Like the comments basically say like, oh, you really should return it because it's consistent with the ethical guidelines we're showing you. Or however, there are circumstances where you might not have to. And what those circumstances are really up to you based on whether there's other rules that apply that make you return it or not return it. I mean, it's very, very unclear. So, again, I think that most lawyers in situations, setting aside our hypo, most lawyers in situations that are send something inadvertently, most lawyers do it is the right thing to do to return it. It's just the right thing. But there's I think that people are in the minority that take it and use it to their advantage just because that's what they want to do. But I feel like majority of lawyers out there would, in good faith, return something that was inadvertently sent to them.
So Ellen,
The
you're our
problem becomes unringing the bell, though, right, Angela? To Sean's point, if it's a one sentence, disclosure, but it's the penultimate issue in the case, it's really hard to push that out of your brain. It's almost easier if it's a 200-page document and they only get through the first
100%.
before they realize, and then they haven't read the rest of it. But if it's a one sentence thing that really is going to drive the outcome of the mediation, that's really hard to undo. And I agree with you. It's a minority of people who are going to take advantage of that situation. But, for, human interest and curiosity being what they are, it's, super difficult to look the other way.
And I also think that embedded in some of these rules, there's that reasonable step I was talking about. So if the other side can show that reasonable steps were not taken to prevent the inadvertent disclosure, then I think that in those circumstances, arguably, they are allowed to use the information. So in here, you could arguably, this lawyer did not take reasonable steps to secure this information. They obviously didn't know how to use the technology. They made the mistake, I think, of using a public chat, and they used it improperly. And they just didn't have any stipulation beforehand about something like this happening. So this lawyer did not reasonably prepare for this. So arguably, the other lawyer could say, well, it may have been inadvertent, but they didn't take reasonable steps to prevent it. And so I can do with it what I want to do with it.
And on a practical, I'm sorry.
I think, Angela, you made a great point there, because I mean, if you sit and write something in the public chat where you're writing a note to your client, it's like 1 or 2 liner, and you put it out there for everybody to see, you've not done good service to your client, certainly. And let's say, for example, you did it and then you realize it. What do? And it's almost, you try and remove it from the chat. And you also, I think you need to, just point out the fact that people should not be able to rely on that. You need to admit you made a mistake and try and rectify it as quickly as you can.
And on a practical point, during the mediation, I always keep the breakout rooms open so that when I'm with the other side, for example, the claimants and attorneys and their experts or whoever else is participating can have private conversations. But I don't just go from respondents breakout to the claimants breakout without calling or texting the particular lawyer on the other side, because I don't want to inadvertently dive in on a private conversation.
And I can confirm that Ellen does do that.
Ellen, I'm going to give you the last opportunity, because we're just at 1:29 and I owe people codes. 30 seconds or less. What is your best piece of advice for people who in the future are going to be mediating virtually in terms of ethics? What's the one takeaway you think is most important today?
I'm just going to go back to preparation. You just don't want the element of surprise. I think that you, like what Sean and Angela and you, Joe, have said, you have obligations that I, as the mediator, don't have to your client. There are no ethical rules. As I said, FINRA points to the ABA ethics rules. There's guidelines published by FINRA and AAA and other ADR providers, but they're not, obligations as a practicing lawyer. I think for the practitioners out there, preparation is more important in a virtual mediation than in a regular one, both to practically get the result and the outcome that you're striving for, and also to avoid any of these ethical pitfalls that we've discussed today.
Last code, Joe.
Last code. All right. So somebody asked me to give you the first code first. So the first code was on mute, M-U-T-E. The second code is off camera. Sorry, wrong. The second code is camera off. We're going to do it again.
No CLE. Nobody gets CLE.
It's on mute and camera off. I want to thank everybody who appeared today. I'm hopeful that this was useful to all of you. I want to thank those of you who spent an hour with us. I want to thank everybody at Bressler who helped us produce and put it together. in the background. Please reach out to any of us if you need to via email. You'll get a follow-up in a few hours. We thank you for being here, and we look forward to doing this again. Have a great day.
Take care.
Thank you.
Thank you.